Gentlemen, I, Jai Trivedi, on behalf of Chairman and members of Justice P.D. Desai Memorial Lecture Committee and trustees of Praline Public Charitable Trust, welcomes you all for 19th Justice P.D. Desai Memorial Lecture to be delivered by Sri Arvind Datar, Senior Advocate, Supreme Court of India, on the topic of 50 years of basic structure, judicial overreach, or constitutional necessity. Before we proceed with today's function, as per our tradition, we shall begin our function with a prayer by Sri Amar Bhatt, Advocate and Member Trustee, Praline Public Charitable Trust. Sri Amar Bhai will render Saraswati Vandana, followed by a devotional song written in Hindi Gurjar, styled by Mukrand Dave, a sanitary poet of Gujarat, in his birth sanitary year.
शुक्लां ब्रह्म विचार सार परमा आद्यां जगद्व्यापिनी वीणा पुस्तकधारिणीं अभयदां जाड्यान्धकारापहां हस्ते स्फाटिकमालिकां विदधतीं पद्मासने संस्थितां हे देवीं परमेश्वरीं भगवतीं बुद्धिप्रदां शारदां हे देवीं परमेश्वरीं भगवतीं बुद्धिप्रदां शारदां हरि का दिया जलाया घट में हरि का दिया जलाया घट में हरि मिलन की ज्योत प्रकाशी रोम रोम की रट में हरि का दिया जलाया घट में बाहर भीतर भया उजाला पायो पीव निकट में हरि का दिया जलाया घट में कहाँ जाऊं रे अब तो सजनी आनंद की उलझट में हरि का दिया जलाया घट में प्रेम दीवाने नयनों को जी प्रभु मिला परगट में हरि का दिया जलाया घर में ओ
Thank you very much, Amar Bhai. May I request Sri Kamal Trivedi, Senior Advocate and Advocate General for the State of Gujarat, and also member of Justice P.D. Desai Memorial Lecture Committee, to give the welcome address.
Good evening to one and all. I deem it a great honor and privilege to address this august gathering of 19th Justice P.D. Desai Memorial Lecture on behalf of our chairman, respected Sri Suresh Bhai Shelat, in view of his inability to join us on account of his indisposition. It is indeed a matter of pride and pleasure for me to join the Honorable Trustees of Praleen Public Charitable Trust and the members of the lecture committee in extending a very warm welcome to you all. We are particularly gratified and happy that Senior Advocate Sri Arvind Datar has found time and agreed to speak to us today. The subject as chosen by him is 50 years of basic structure, judicial overreach, or constitutional necessity. Today, we have also with us Honorable Ms. Justice Belaben Trivedi and Honorable Mr. Justice J.B. Padiwala, Judges Supreme Court of India. Present as well as former Honorable Judges of the High Court of Gujarat, Honorable Mr. Justice C.K. Thakkar, former Judge, Supreme Court of India, Honorable Mr. Justice Mohit Bhai Shah, former Chief Justice of Bombay High Court, Honorable Mr. Justice Kalpesh Bhai Javeri, former Chief Justice of Orissa High Court, learned Advocate Generals of states of Rajasthan and Orissa, members of our legal fraternity, directors, faculty members, and students of National Law Schools, GLS University, Gujarat University, and Nirma University, and the leaders of print and electronic media. It is really heartening to see that we have again got together under the auspices of Praleen Public Charitable Trust, founded by a great and eminent judge, Sri Prabodh Bhai Desai, whose memory always serves as a beacon light for all of us. He worked hard and left his heritage for the upliftment of weaker section and the legal fraternity. His sterling qualities endeared him to all, coupled with great regard and reverence. The trust has been working incessantly to further and promote its objects, over and above organizing thought-provoking lectures and seminars. The trust has contributed generously over the years in the fields of education, providing medical aids, and empowering women and people in tribal areas. The trust has provided funds to a hospital at Jagadia, SLU College for Women, as well as to the institutions working for the benefit of mentally and physically challenged people. I know that our today's guest needs no introduction, but his achievements require a special mention before this gathering. After graduating with the subjects of physics and mathematics, Sri Datar did his law, and while pursuing the cost accountancy course in the year 1982, enrolled at the bar and soon established himself as a formidable lawyer. Sri Datar was designated as a senior advocate by Madras High Court on 18 July 2000 and has successfully handled many matters of constitutional law, corporate law, SEBI laws, and direct and indirect tax laws before various high courts, including the Madras High Court and the Supreme Court of India. He has also appeared in a bilateral investment treaty arbitration held at International Court of Justice at Hague. With more than 40 years of experience practicing in various high courts and the Supreme Court, Sri Datar is the prominent senior advocate and one of the finest lawyers our country has produced. He has appeared before the Supreme Court in several landmark cases, including the Vodafone income tax case, the National Tax Tribunal case, the SEBI Sahara case, the NJSE case relating to appointment of judges, and many other important cases. A lawyer par excellence and a successful cost and works accountant, P.Datar is one of the few distinguished Indian lawyers to get called to the chambers in the United Kingdom, having joined Fountain Court as a barrister. Till date, he has written over 300 articles in a number of journals and newspapers. In addition to this, he also authored several books like Datar's Commentary on Constitution of India, 2nd edition, Guide to Central Excise Law and Practice, 7th edition, Guide to Central Excise Procedures, 2nd edition. He is the chief editor-in-chief of 18th edition of Ramaya's Guide to Companies Act and chief editor of the forthcoming 11th edition of Kanga and Palkhiwala's Law and Practice of Income Tax. Apart from this, he also co-authored a book with Soli Sorabji on the legal journey of Nani Palkhiwala titled The Courtroom Genius. And he's also the general editor of Essays and Reminiscences, a festschrift in the honor of Nani Palkhiwala. Shri Datar has also held various prestigious positions in several philanthropic associations, like a trustee in Palkhiwala Foundation, director in Nani Palkhiwala Arbitration Center, chairman of Maharashtra Building Trust, chairman of Maharashtra Building Trust, and joint secretary of Tamil Nadu Mediation and Conciliation Center. As we all know, today's subject of memorial lecture is very much live and interesting. The term basic structure has not been defined in the Constitution, but the concept thereof has been evolved by the Supreme Court through its numerous landmark judgments over the years. It was in Keshwanand Bharati's case that the Supreme Court rendered a historic verdict with reference to the basic structure of the Constitution roughly before 50 years, that is on 24th April 1973. In the said case, 7 honorable judges, while upholding the validity of 24th, 25th, and 29th amendments to the Constitution, ruled that the amending power of the Parliament conferred under Article 368 of the Constitution could not be used to emasculate the basic structure of the Constitution and the fundamental rights. Whereas the minority view of 6 honorable judges was that the amending power of the Parliament was unrestricted and could be used to amend any basic structure of the Constitution, including the fundamental rights. In my view, the said ruling rendered in Keshwanand Bharati's case is the greatest contribution of Republic India to constitutional jurisprudence of the country. However, there are 2 major schools of thought, one of which justifiably believes that by the said verdict, though the mutt in that case lost his properties, in view of the constitutional amendments having been upheld, the constitution of the country was saved. Whereas the second school believes that ultimate legal sovereignty resides in the people. Wherever one may place their allegiance, it is undeniable that the doctrine of basic structure is essential to the constitutionalism in the India. However, it is my personal opinion, subject to any other opinion, that the said doctrine needs to be revisited by the Supreme Court in an appropriate case, and the aspects such as its applicability, content, and the scope need to be elucidated in unambiguous terms. Now it is time for me to request our today's esteemed guest to share his thoughts on the subject in question. We are all eager to listen to him. Thank you very much.
Thank you very much, sir. It's an honor and privilege to invite Sri Arvind Datar, Senior Advocate, Supreme Court of India, to deliver the memorial lecture on 50 years of basic structure, judicial overreach, or constitutional necessity.
Good evening to all of you. I must first thank the members of the P.D. Desai Memorial Lecture Committee for having bestowed this honor on me. I think it's a great privilege and a humbling experience to be invited to speak on for the 19th Memorial Lecture. The speakers before me have been of great national eminence, and that is why it's a special privilege that I can deliver this lecture to perpetuate the memory of this great person. I must also thank members of the Praline Trust. I must thank Sri Kamal Trivedi for the kind and generous words. I'm also happy to note that learned Supreme Court judges present and retired, High Court judges present and retired have taken the time to spend the Saturday afternoon listening to this lecture. My encounter with Justice P.D. Desai was very unique and unusual. Chief Justice A.P. Shah was the Chief Justice of the Madras High Court between 2005 and 2008. I had gone to see him to invite him for some function, and the chambers of the Chief Justice of the Madras High Court is very huge, very majestic. It's a huge table there, and as I went to meet him, I saw a portrait, a photograph of a very genial elderly gentleman, and I asked Justice A.P. Shah whether it was his father. And he said, no, this is Justice P.D. Desai. Don't you know? He's one of the greatest Chief Justices India had. And then he proceeded to tell me that Justice P.D. Desai was the Chief Justice, had been the Chief Justice of no less than 4 High Courts. And in every High Court, he left his mark. He then told me that how after retirement, he took up the cause of resettling people who had been displaced in the Narmada Dam, and he did his work with great dedication, and it was perhaps the best resettlement undertaken so far. And what's most remarkable, that he did it completely free, he did it as a duty to the nation. Later, when I started looking up about this gentleman, about this great judge, I found that virtually everybody I spoke to uniformly spoke about Justice P.D. Desai with almost veneration, reverence, if I may say so. Justice Rumapal and Justice Deepak Gupta, both of the Supreme Court, held him in the highest esteem. So it is particularly gratifying that we cherish his memory by having an annual lecture, and it's a personal privilege that I could speak on this topic. By a happy coincidence, when Sri Shelat asked me to choose this topic, we first started hearing the rumblings of whether the basic structure was the correct thing done by the Supreme Court. Was it something which was a judicial overreach, where the Supreme Court sought to get over the will of the Parliament, which represents the will of the people? And therefore, I thought that I would speak on basic structure. Was it a judicial overreach or was it a constitutional necessity? Now, I've divided my talk. I tried to propose to speak for about 30-35 minutes. I'm told that in the YouTube age, the attention span of listeners is shrinking. And typically, if it's more than 20 minutes, you just lose your audience. So I'll try to be as brief as possible. And I've divided my talk into 4 parts. The first is what led to the basic structure. The basic structure came in 1973, almost a quarter century after the Constitution was formed. Secondly, what was the formulation of the basic structure? What does it mean? Third, how was it applied? What was its role in saving democracy? Fourth is the burning topic. Is it really a stumbling block? Does it require revisitation? Has the Supreme Court gone wrong in even thinking of this doctrine or not laying down the parameters of this doctrine? So these are the 4 broad parts in which my lecture will be divided. So let me straightaway go to what led to the basic structure. Now, right from the word go, right from the start of the Constitution, the series of land reform legislations were struck down by the Patna High Court and other high courts. You have the Kameshwar Singh case and so on, mainly on the ground of compensation, on the ground of Article 31. These judgments threaten to derail the entire process of agrarian reform. And therefore, we had this very unique proposal, which was incidentally suggested by an eminent Advocate General of the then state of Madras, who suggested let's have a ninth schedule and let's have Article 31B, so that anything which is put inside the ninth schedule gets a kind of an insulation from any challenge under the Constitution. So this was a very unique provision in any constitution, where the Constitution itself makes certain parts of it unchallengeable. And then you had the first acts which were placed in the ninth schedule. Then you had the Bela Banerjee's case, the Fourth Amendment, other amendments came on. And fast forward to 15 years, in 1965, the 17th Amendment was passed. Thus, the Constitution was amended 17 times in 15 years. And the 17th Amendment inserted no less than 44 land reform laws into the ninth schedule. So, by 1965, you had 64 entries in the ninth schedule. This was challenged. Now, when this was challenged in Sajjan Singh versus State of Union of India, the earlier judgment in Shankari Prasad was already there. In Shankari Prasad, Chief Justice Patanjali Shastri made it very clear that the power of the Constitution to amend was untrammeled. He also made it clear that when the Constitution is amended, it is not law under Article 13(2), it is under a constituent power. And therefore, until 1965, the supremacy of Parliament, that is the power of Parliament to make any amendment it chooses of any provision, was not questioned. The first warning, the first caution was sounded in the judgments of Justice Hidayatullah and Justice Mudholkar in the Sajjan Singh case. Now, you can't technically call it dissenting judgments because they concur in upholding the validity of the 17th Amendment, but they first sounded the words of caution. Justice Hidayatullah said that for whatever reason, Article 368 enables the taking away of fundamental rights by a 2/3 majority. He pointed out that Article 32 could be taken away by a 2/3 majority, but if you wanted to take away 226, you had to go to the majority plus ratification by the states. So he said this was an anomaly, and then he said that it is difficult to believe that people would allow fundamental rights, which are so elementary to a democratic constitution, to be treated in the same way as other constitutional provisions. And he used a very interesting word. He said, I am not very sure that the fundamental rights are the playthings of a majority. Playthings of a majority. The next judgment, which is perhaps the most important judgment and the most important turning point, is the judgment of Mudholkar. And to my young friends who are listening, I would earnestly request you to take AIR 1965 Supreme Court, page 845, and read the judgment of Justice Mudholkar. He starts off with judgment by saying, I'm concurring with the view of Justice Gajendra Gadkar. And incidentally, Justice Gajendra Gadkar, though he upheld the 17th Amendment, he, in the last paragraph, he puts a nice paragraph. He says that Parliament should consider whether amending fundamental rights should be put in the proviso to Article 368(1). No, the proviso says that you can't amend it without the ratification by the states. So he just says, please consider whether fundamental rights requires ratification by the state, but he doesn't strike it down. Mudholkar goes the whole distance. And in a remarkable judgment, he points out that it's time to pause. Can you take away fundamental rights by a simple amendment? He says, are there not certain essential features? He uses the word basic feature thrice. Are there not certain basic features of our constitution which cannot be taken away. And he refers to a judgment of the Pakistan Supreme Court, where in the 1962 Constitution of Pakistan, the President of Pakistan under their Article 224 could make amendments to the Constitution to remove difficulties. And they amended the law to say that whatever the President does will be beyond judicial review. That was held to be violative of the Constitution, and Chief Justice Cornelius said that there are certain essential features which can't be taken away. Mudholkar refers to that and says that our Constitution has certain essential features. And what is most important, which people should note, is that Mudholkar asked the question, what are the essential features? Where are the essential features in our Constitution? And he then points out, look at the preamble. He says our preamble contains the basic values, liberty, equality, fraternity. These are our essential features, which he says are concretized. Use the word, they're concretized in the other articles of the Constitution. And these are the essential features. And then he says that although I have upheld the amendments, I do not agree fully with the reason of Shankari Prasad. And he makes it very clear that it's time for a relook. 2 years later, Golaknath went, of course, to the entire extreme and said that you can't touch. Law includes Article 13. Law in Article 13 includes an amendment. It went to all the way. Of course, because of prospective overruling, the other amendments made were not disturbed. This was, of course, widely criticized, and immediately in 1973, this came up for consideration before the Supreme Court. And we now come to the Kesan Bharati case. Therefore, what led to the basic structure were the frequent amendments, the putting of matters in the 9th schedule, and where the citizen was remediless if his fundamental rights were taken away. And therefore they said that are there certain essential features which can't be tinkered. Now you come to the Kesan Bharati case. What led to the Kesan Bharati case? Now just remember that after bank nationalization, after Golaknath, you had the bank nationalization case. In 1969, you had the Privy Purses case, and then you had Kesan Bharati. Now, if you study Kesan Bharati very carefully, it basically, 4 amendments were under challenge: 24, 25, 26, and 29. 24th Amendment simply said, amended Article 368 and 13 and said, law in Article 13 will not include an amendment. The 25th Amendment made a change in 31 and said that compensation will be replaced by an amount. And the 25th Amendment amended 31C and made it very clear that if a law said that it was intended to implement directive principles, it was beyond challenge. I'm just speaking very broadly because of the shortage of time. 26th, of course, Amendment abolished the Privy Purses, and 29th added the 2 Kerala laws, which Mr. Trivedi mentioned about Mr. Kesan Bharati, and it was added in the 29th Amendment. In fact, in Mr. Andarujana's book, Mr. Andarujana was telling us, and it's in the book, that Mr. Kesan Bharati used to be surprised why his name is coming in the paper every day. He has done nothing wrong. He said, why is my name coming every day? They said, no, yours is the lead matter, and therefore your name is coming. And so one Swamiji from Kerala became immortal, though his matter was just concerning 2 land reform laws. Anyway, so these amendments. Now I want to mention one thing. We all think Kesan Bharati was a great check on the parliament and the judiciary was overreaching. If you study carefully, everything in Kesan Bharati went the way of the government. 24th was upheld. 26th was sent back and then later on upheld in Raghunath Rao's case. 29th was upheld. 25th, first part was upheld. The only thing which was struck down was the second part of Article 31C, which said that if a law was intended to give implementation to directive principles, you could not challenge it. You could not even tell the court that this law is not intended to implement directive principles. It's a colorful exercise of power. That went too far. So if you see that way, the allegation that judiciary is overreaching is not sustained even on the Kesan Bharati case, where almost every law was upheld. Similarly, bank nationalization, nationalization was upheld. It was struck down only because the compensation was so narrow and payable after 10 years that it was struck down. Now, coming back to Kesan Bharati, Mr. Trivedi mentioned that what are the essential features, where are they defined? According to me, Mudolkar's judgment gives an answer. If you read the judgment of Kesan Bharati, Mr. Nani Palkewala gave 12 essential features, and they have been reproduced in the judgment of A. N. Ray. Chief Justice Ray is the only judgment which reproduces the 12 principles mentioned by Mr. Palkewala. But what is most important is para 1426 at page 767 of the SEC reports of Kesan Bharati. That paragraph should be read again and again. Para 1426 at page 767 of H.R. Khanna's judgment, Justice H.R. Khanna's judgment. Justice Khanna goes into the meaning of the word amend, alter, repeal, vary, etc. as used in the Constitution. And then he says, 368 doesn't say amend any provision of the Constitution, it says amend this Constitution. So he says when you amend this Constitution, after the amendment, the old Constitution continues. So what is this old Constitution? And he says the old Constitution means the essential Constitution which contains secularism, freedom, democracy, upper house, lower house, and so on. So he sets out in para 1426, and that is how one single paragraph saved us from dictatorship in the years to come. Like the Berlin Wall was a division between freedom and repression, para 1426 was really the Lakshman Resha which separated democracy from dictatorship as years to come. Now, the subsequent paragraphs are also there where he discusses all the things. And the other important feature of Justice Khanna's judgment is he rejects the thing of will of the majority, which is touted so much nowadays that Parliament represents will of the people. He says that the referendum also is not an option because referendum talks of the majority. And the essence of a constitutional democracy is that the minority is protected even though it doesn't have a proper voice. Even a small minority is entitled to protection under a constitution. So all these arguments about majority, will of the majority are debunked by Justice Khanna's judgment, and he upholds basic structure. I must also mention, I mentioned this in other lectures, we keep saying Kesan Bharati is 7:6, and I keep saying that it is 6.6:6.4 because Justice Khanna agreed with the majority in every way. Only on basic structure he shifted in para 1426 to para 1430. So Justice Khanna really upheld, he said, yes, right to property is not basic. He upheld 24, upheld everything except 25 remaining part, he struck down. So this was what the basic structure came. And to answer what is basic structure, I think a good exposition is Justice Chandrachud's judgment in the Indira Gandhi case, where he sets out 5 essential parts which can form the basic structure. But I will go back to Mudolkar's judgment for a minute. He says you have got the power to amend the Constitution. And he asks a very important question. Suppose under 368 you amend the Constitution. You delete Article 14, delete 19, delete Article 21. Justice Mudolkar asked the question, if you delete these essential things, is it the same Constitution? Is it a Constitution at all? And that is the answer as to what is basic features. Now, having seen what led to the basic structure, what is the basic structure, I've also tried to analyze with my colleagues what is the jurisprudential basis of basic structure. So they say, okay, basic structure is there. Why is it there? Effectively, by the basic structure, a constitutional amendment becomes unconstitutional. It almost sounds paradoxical that a constitutional amendment is unconstitutional. And why? And there you can read the writings of Yaniv Roznai, of the Israeli scholar. You can see some South African literature, some Colombian literature, where they say, in a written constitution, the legislature, the executive and the judiciary are delegates. They have been delegated legislative power, executive power and judicial power. So the constitution confers powers on these 3 organs of government. And they go by what is called the principal agent theory. Just as an agent cannot act against the principal, these delegates cannot go against their mother document. They also take the example of just as a subordinate legislation, a notification cannot go against the Parent Act, or a subordinate legislation cannot go against a primary legislation. A primary legislation cannot go against the Constitution on the basis of which it has been formed. So apart from the Supreme Court, there is also, in my humble view, a jurisprudential basis to say that once there is a written constitution, the delegate cannot destroy the essential features of that constitution. If you read Dieter Conrad's article, he puts basic structure very interestingly. You know what he says? He says basic structure is in Article 1. Article 1 says India shall be a union of states. Is a union of states. Now, can you say that India will not have states? Everything will be union territories. If you say the power of amendment is supreme, tomorrow can they say there are no more states, all are union territories. There is no more high court. So these points are highlighted by Dieter Conrad. And mind you, after the basic structure doctrine was put, look at what it could be used to protect our constitution. Immediately after the basic structure came the emergency. In the emergency, you had the 39th Amendment, which said that the elections of President, Prime Minister, Speaker, and the 4 people will be beyond challenge, which went to Indira Gandhi versus Raj Narayan and was held to be violative of basic structure. Article 329(4) was held to be violative of basic structure. So you are able to protect, you are able to establish that nobody is above the law. Just because you're the Prime Minister, that doesn't mean you can do any practice in your election and it will not be questioned. Very important. What is shocking and often forgotten, the 40th Amendment Bill became the 39th Amendment. We have forgotten about the 41st Amendment Bill, which never saw the light of the day. And the 41st Amendment Bill said that if you are the President, the Vice President, the Prime Minister, or the Governor, then under amended Article 361, which proposed to amend, you had a lifetime immunity from any civil or criminal prosecution. So a man can be a governor for one day, he can commit murder, he can commit anything, he will not be liable for prosecution. Fortunately, it never came, but I dare say that if it had come law, it would have been struck down as being violative of the basic structure. You can't say that just because I am the governor or prime minister, I'll not be subject to IPC or CRP. And the worst of all was the 42nd Amendment. I see so many senior people here who must have lived in the emergency, lived the 42nd Amendment. And it is worthwhile, those persons who now think of taking away the basic structure, please go home and read the 42nd Amendment. Read the clauses in the 42nd Amendment. A High Court could not strike down a central law. A High Court could not strike down a law unless it was a bench of 5 judges or 7 judges. It required 3/4 majority. So it became almost impossible of judicial review. And this 42nd Amendment, which the learned jurist, Mr. Sirwai, who argued case on Bharati, who opposed the basic structure concept, he himself later agreed that the 42nd Amendment was an outrage. He used the word outrage on the Constitution. And the 42nd Amendment was struck down in Minerva Mills. What did it say? The amendment to 368 says that every constitutional amendment from 1950 and every constitutional amendment in future can never be challenged. Complete immunity amendment. This was held to be unconstitutional. Section 4 and 5 of the 42nd Amendment was struck down. So you had basic structure which has been used in Kesan Bharati, in Indira Gandhi's case, in Minerva Mills case, in Samba Murthy's case, where Article 371D, that judicial review was taken away, was struck down. In Kyoto Holowan's case, L. Chandrakumar's case, where they said that the matter which goes to the tribunals under 323 and 323B, 226 is gone. And the Supreme Court in Chandrakumar laid down that Article 226 and 136 are part of basic structure. Now, for the rest of our lives, unless we have a 15-judge bench and we overrule basic Kesan Bharati, for the rest of our lives, every citizen has the protection of Article 226. And of course, so it has been applied in these cases. And we must also note Coelho's case, where Coelho says that even if it is in the 9th schedule, if the amendment has come after 24th April 1973, it can still be challenged on the violation of basic structure. So basically, a primary law can be challenged on many grounds. But if it's a basic constitutional amendment, it can be challenged only on a very, very narrow thing of violating basic structure. Now, before I go further, the basic structure was never really accepted by the then government. We all know the clumsy attempt to review the basic structure. It is almost an embarrassment for the Supreme Court that they assembled for 13 judges assembled to review basic structure. Please read in Courtroom Genius, we have given it also in Prashant Bhushan's book. What happened in the court has been recorded. One learned judge said that Mr. Palkhiwala said, why do you want to review it? He said, basic structure is not defined. We don't know what is basic structure. And Mr. Palkhiwala's argument was that he said, I never knew that I'll be hearing a case where the Supreme Court did not understand its own judgment. He spoke so strongly about it. And H.R. Khanna said that till today, nobody has argued better than his impassioned two-day plea to save the basic structure. And Gujarat and Tamil Nadu have a role to play. When Palkhiwala asked, who asked for this review? There must be a review petitioner. Who's filed his review petition? He assembled 13 judges. And I've got it on tape. I've interviewed Justice Chandrachud and others on this issue, wherein I wrote Courtroom Genius with Mr. Swarabji. So I believe he asked the question. And then Justice Ray said, I think Gujarat requested for it. J.M. Thakur, who was the Advocate General, got up and said, we never asked for a review. Then he said, Madras, Govind Swaminathan of Tamil Nadu said, we never asked for a review. Once it became clear that nobody had asked for a review, Justice Ray said the bench is dissolved. So the attempt to review Kesan Bharati also went away. Then you had the 42nd Amendment, which tried to nullify Kesan Bharati. That also, fortunately, was struck down in Minerva Mills case and in L. Chandra Kumar's case. Now I come to the fourth part of my talk as to, is it a stumbling block? Is it coming in the way? Now, all the people who critic basic structure, they say, no, let us look at it again. What is basic structure? What is essential feature? I ask a simple question. Tell me which proposal that an elected government wants to do is interdicted or is thwarted, or the basic structure doctrine is a stumbling block in what you want to do for social development or to meet your constitutional ends. Tell me one example which can't be met. Of course, I forgot to mention the NJC where I had the occasion to appear. The 19th Amendment was struck down. But if you see the NJC Amendment and if you see the NJC Act, it's an absolutely unworkable principle. Now, if the amendment is struck down, the answer is not to attack the Supreme Court and say you're going against the will of the people. Redo the law. Now, see what I'm saying. In the reservation cases, Supreme Court used to pass a judgment saying that you can't go beyond a percentage, whether it's Indira Sani or subsequent judgments of the Supreme Court. What did Parliament do? They passed amendment after amendment, restoring reservation. All these amendments were unanimous. So, due to shortage of time, what were the amendments which overcame Supreme Court judgments? 77, 81, 82 and 85. 4 amendments amended Article 16 and amended Article 335. All these amendments were considered in Nagaraj's case and upheld. And Justice Kapadia then expanded this thing of applying the wit test and identity test. So, I would submit that the Supreme Court has never come in the way of social reform or stopped the intention of Parliament to implement a reservation or its social policy. Take the new 103rd Amendment of the EWS category. I think it's a correct amendment. In my personal view, it's a correct amendment. I've got my own views. It doesn't breach 50%, but there is no time to discuss that. But even the 103 amendment was upheld by the Supreme Court. So I'm still completely puzzled by critics who want to say, you want to revisit. You want to revisit which part of the basic structure? Are you going to say that equality is not basic structure? Right to speech is not basic structure? Judicial review is not basic structure? What are you trying to say? So unless you can come to a concrete example and say, apply the Hayden's mischief rule, that this is the point we want to implement, here's where the basic structure is coming in my way, I want to remove the stumbling block. Till today, there is no answer except to say, no, I want to take away basic structure. That was the argument. It was thwarted in the review case. The 40th Amendment was struck down. And I sincerely hope that we don't have an occasion to review the basic structure. Now, I'll come to the end of my talk. See, the danger is not to be discounted. In a country like Israel, recently Benjamin Netanyahu became the prime minister for the third time. There is a very good Israeli constitutional scholar called Yanni Rosnak. You will be shocked to know what is the recent amendment which has been placed before the Israeli Knesset. Their parliament is called the Knesset. I was shocked to note that Israel doesn't have one written constitution. It doesn't have one constitution. It has series of basic laws which are framed by parliament. Now, do you know what is the new amendment which the Constitutional Law Committees propose in Israel? Only the Supreme Court can strike down a law, and at least 13 out of the 15 judges should sit together and strike it down. So out of 15 judges, 13 must strike it down. All right, no problem. Now look at the amendment. If 13 out of 15 judges, that is 80% majority, says that a law is unconstitutional, the further provision says Knesset can reintroduce the bill. It has 120 members. If 61 members want to do, they can override the Supreme Court judgment. So look at the absurdity. You pass a law, must be by majority only, otherwise you can't pass a law but by majority. That majority law goes to Israeli Supreme Court. Israeli Supreme Court strikes it down by 13:15. And if they strike it down, it comes back to Parliament and the same majority passes it back. So this is the law which is sought to be, and he says this is most dangerous. And then Professor Rosnai makes a very, very important thing which we must bear in our mind and not forget. He says recorded history does not have one example where a democracy has collapsed because of judiciary overprotecting human rights, but no democracy has survived where the legislative and executive power does not have adequate checks. This is the recorded history of things. So let us pause and consider when we think of taking away the basic structure. Friends, I have come to the end of my talk. I'll just conclude by saying that, yesterday, 2 days ago, when I heard the budget, I'm told that 2023 is the starting point of the Amrit Kal, and we're going to have Saptarishis going on till 2047. It's an ambitious, audacious target, and all those goals are very laudable, and it will be really an Amrit Kal if those goals are achieved. But I would venture to suggest that for a Republican democracy, if it has to be in the Amrit Kal, then the most important Saptarishi of a Republican democracy is the rule of law. The most important pillar of the rule of law is a written constitution. Israel is in trouble because it doesn't have a single constitution. The most important pillar of the rule of law is a written constitution. The most important pillar of the written constitution is its basic structure. And I'll conclude by saying that late Justice P.D. Desai devoted his life to preserving law, and let us all, at the beginning of this Amrit Kal, dedicate ourselves and pledge ourselves to preserve, protect our constitution and ensure that the basic structure is never touched. Thank you.
Thank you.
Thank you, sir, very much for your thoughts. Now, may I request Sri Bhaskar Tanna, Senior Advocate and also the member of Lecture Committee, to propose the vote of thanks.
Thank you, Mr. Datar. We are very particularly students would be too happy to understand the entire gamut of arguments which went in a ding-dong manner, and they would be really enlightened. Thank you very much. I must also, on behalf of trust, it's a rare thing, but thank Suresh Bhai Selat. Despite the fact of his health, he has definitely taken care of everything. I would like to say a couple of things for students and others, that to debate in our constitution, first of all, is one of the finest experiments we have done. But two issues are going to be always in debate. One is basic structure, and second is whether judges can appoint judges. And this debate will go on, and that's a nice thing for those of us who are academicians and who would like to read Sirvai, even old volumes. Anyway, further, I would like to thank all our present and past Supreme Court judges, present and past High Court judges, and we are very happy that we have completed 19 years. But students and lawyers of now, I can see all High Courts coming in, and in new era of post-COVID Zoom situation, it's a nice thing to happen that everyone can now come and listen to it. So I must thank all volunteers who worked, students, our advocates and judges. Thank you very much.
Thank you all very much.
Thank you.
Thank you very much.
Thank you.
Thank you. Can I leave?
Thank you, Mr.
Thank you so much, everybody. Thank you.
Thank you, Mr. Datar. Thank you very much.
Thank you. I'm so happy to see Justice Thakkar also here. Thank you so much.
Yes, there are almost 120 people online.
Thank you. Thank you. I'm so glad. And wish Mr. Sheila the speedy recovery.
Yeah, they will convey.
Yes, we all